Good morning, everybody, and I'd ask you please to take your seats so that we can start with our 5th OECD Competition Open Day. Good morning. So to start this open day, we have a video from the Secretary-General, who unfortunately wasn't able to be with us. So could you please start the video from the Secretary-General?
Dear Chair, Frédéric Jenny, ambassadors, colleagues, friends all, a very warm welcome to this 5th annual OECD Competition Open Day. This event is an opportunity for the OECD to open our doors to the global competition policy community and to share our work on competition issues over the past year with a broader audience, including academics, competition law practitioners, and indeed businesses. This past year has certainly been very productive on the competition front. The OECD contributed to the evidence based on global competition policy with new inventories on digital regulatory reforms and with international cooperation agreements. We helped build agency capacity with workshops in Paris and our 3 regional centers in Budapest, Lima, and Seoul, as well as a peer review of Tunisia's competition law and policy framework. We hosted 9 roundtable discussions with competition agencies at the cutting edge of developments, including the topics you will be discussing here today. A very warm welcome in particular to the heads of the Australian, French, Mexican, and Spanish competition agencies who are here with us today. Our discussions today will greatly benefit from your insights, from your analysis and observations on the current state of competition policy. I know I'm preaching to the converted here today when I say that competition is a key driver of economic growth and well-being. For consumers, it is what drives increased choice and better quality at lower prices, which is especially relevant at a time of rising prices and growing pressure on household and government budgets. But it is also a powerful catalyst for progress on our structural reform priorities, by helping to boost productivity and economic output to drive much-needed growth, by incentivizing efficiency in the wake of high global commodity prices, by stimulating the innovation needed to secure the sustainable transformation of our economies and to fully harness the benefits of digitalization, by driving the increased diversification of supply chains to improve the resilience of our economies, and by ensuring a fair deal for workers through dynamic labour markets. More broadly, pro-competitive policies help to advance the OECD's fundamental values and principles. Competition policy can safeguard democratic processes from undue influence by preventing the emergence of an unhealthy concentration of economic power. Indeed, preventing inappropriate concentration of economic power is one of the keys to ensure more equitable and inclusive growth. Our analysis shows that higher levels of market power can further reduce the wealth of the poorest 20% by between 14 and 19%. Competition can also help ensure merit-based equality of opportunity, a fundamental democratic promise, including by keeping markets open for innovative new entrepreneurs. Competitive outcomes are not guaranteed to emerge on their own. They require the right policy framework, they require the right policy settings. Transparent, objective government decision-making, free from corruption and arbitrary processes, the rule of law, regulatory frameworks that do not create unnecessary barriers to competition, whether by preventing new players from entering markets or by distorting incentives to set the lowest prices and provide the best quality. And of course, effective and vigilant competition law enforcement agencies that prevent illegal conduct and anti-competitive mergers. The OECD provides standards, best practices, tools and research for each of these elements of a holistic competition policy framework. Today's panel discussions will highlight just some of this work over the past year. First, the annual competition trends publication, which provides policy and enforcement indicators for 79 jurisdictions. This year's edition shows that enforcement activity is on the rise, with total fines among participating jurisdictions having increased by 53% between 2020 and 21, from $5.6 billion US to $8.5 billion US in 2021. The number of dawn raids of businesses began to recover from the COVID-related lows in 2020, but was still below 2018 and 2019 levels, suggesting that the impacts of the pandemic on agency activity lingered on. We have observed continued efforts to tackle abusive conduct by firms that are dominant in their markets, including and in particular in the digital sector, which is encouraging. Budgetary pressures, though, are increasing. Average total budgets in non-OECD participating jurisdictions even declined slightly in 2021 relative to 2020. Competition policymakers will need to continue to make efforts to better explain the significant returns of competition law enforcement activities for consumers as well as for businesses and the economy as a whole. Second, our work on enhancing the effectiveness of competition law enforcement. You will hear today about the role of interim measures, such as orders to restore previous contractual terms, while an agency investigates the competitive impact of new terms. These measures allow competition agencies to intervene quickly and to protect markets while investigating possible competition law infringements. Interim measures can be especially valuable in fast-changing markets, such as those in the digital sector, where competition harms cannot be easily undone. Yet so far, these measures are, in fact, rarely used. Today's panel discussion will explore some of the challenges that might explain why, including the need to ensure due process is protected and to ensure these tools do not create excessive uncertainty for businesses. Third, our work on the relationship between competition and inflation. The last OECD Economic Outlook in November showed that inflation hit 10.8% on average across OECD economies. Higher prices and weak real income growth has contributed to a sharp slowdown in many countries. Competition contributes to reducing long-run inflationary pressures and prevents anti-competitive behavior from exacerbating inflation. It does so by pushing firms to keep prices low and therefore use inputs efficiently. Effective competition enforcement will also prevent firms from using broader inflation trends as a cover to collude with one another and to further increase prices. However, we should not be expecting competition agencies to provide a quick fix to current inflationary pressures, given some of the underlying causes, in particular, a series of highly exceptional supply shocks. In closing, competition policy is an incredibly important part of our broader economic policy toolkit. It needs to adapt to changing product markets, new threats, and an evolving macroeconomic context. The OECD's standards and tools on competition policy contain key principles and practical advice for navigating some of these changes and developments. They are enhanced by the discussions, research and policy analysis carried out in the Competition Committee under the leadership of its outstanding chair, Frédéric Jenny. We are pleased to share with you today some of these insights from these discussions. Thank you once again for joining us and for your interest in effective competition policy, which will help us achieve a more prosperous, dynamic, innovative, and inclusive economy.
Thank you. I'd like to turn the floor over to the chair of the OECD Competition Committee, Dr. Frédéric Jenny.
Ladies and gentlemen, it's my great pleasure to introduce today the OECD Competition Open Day, which has become a yearly event for the last 5 years, except it was somewhat disrupted by the COVID crisis, which forced us to have it online last year and the year before. Now, this event gives us the opportunity to present to the wider community of lawyers, economists, competition authorities who are non-members of the OECD, and anybody who is interested in competition issues or in related fields of work, the work which has been done by the Secretariat during the past year at OECD to further the agenda of the OECD Competition Committee. This work, I would like to note, is particularly valuable for the Competition Committee as it constitutes, together with some of the the outside experts' work, it constitutes the background to the debates and the discussions that take place in the committee. As those who are not entirely familiar with the OECD might not know, but the committee is composed of the representative of the 38 OECD member countries, plus the delegates of 2 associates, plus 13 participants from other jurisdictions. So we're talking together about a membership of about 53 countries who meet regularly to discuss competition issues in the context of OECD. The agenda of the Competition Committee has changed over time, just like the economic debate has changed over time, and it's very noticeable that indeed our preoccupation mirror some of the wider preoccupation in the economic field. Historically, I've been around for a while, so I can have a historical perspective, but historically, we were very concerned with market liberalization in the 1970s, and from there we went from market liberalization to regulatory reform, which was a major theme in the 80s. From regulatory reforms, we went to economic globalization, which was one of the important themes of the 90s. From globalization, we moved to the issue of resilience, particularly at the time of the financial and economic crisis of 2008. And from resilience, we moved to inclusive growth, which was around the end of the first decade of the 2000s. From inclusive growth, we moved to how we could adapt competition law to the digital transformation. And more recently, and I'm going to talk a bit about this, from the digital revolution, we moved to issues of sustainability, industrial policy, and the emergence of regionalization in international trade. So 2022 has been a year of transition for the Competition Committee of OECD, and this transition reflects some of the aspects of the evolving economic concerns which I've just outlined. Now, as those of you who participated online to the previous edition of this OECD Competition Open Day might know, we have spent quite a bit of time over recent years to deal with the digital transformation. Now, one of the interesting aspects of the digital transformation is that it taught us, the competition community, 2 things. One of them was that competition law and policy was very well adapted to a particular type of competition, to a particular model of competition. And I mean by this a competition by firms who are present on the market, try to outdo each other to get the favors of consumers. They sell similar substitutable products, sharing essentially the same business model and competing mostly on price and possibly on some other dimensions such as quality and innovation. But what we've learned at the same time is that the competition law instrument and our competition regime needed to be profoundly adapted to situations where ecosystems, rather than firms, were competing with each other. where such ecosystem or platforms were centered on the use of a technology which was easily adaptable to deliver a number of different services, rather than being focused on one particular market. To a world where such platforms offer, therefore, combination of complementary services on multi-sided markets in the presence of strong scale, network, and scope economies. And finally, where they compete on innovation more than on price. In addition to this, of course, competitors in the digital field can have very different business models. And this is a situation which is not so common in, it can happen in real non-digital sectors, but it's not so common. So in order to face those issues, we have to start from the premises of competition law, but we have to adapt the tools to assess, to be able to assess the competitive situation. The second dimension of the discussion on the digital was a discussion on the possible difficulties that competition authorities had to tackle giant tech platforms, particularly their mergers, as well as their perceived abuse of dominance. And this led to, in some countries at least, a discussion about whether the consumer welfare paradigm was really adequate to the task, and whether the goal of antitrust should not be wider and to fight economic concentration. So that was the second dimension of the discussion. The third dimension of the discussion was whether competition law was an adequate tool to tackle dynamic markets, and whether regulation, and in particular ex-ante regulation, was not a more adapted tool. So there was an issue about whether the tool itself, put aside from the way in which it was used, was adequate. Now, as many of you know, we spent the better part of 4 years in the Secretariat and in the committee looking at those issues. We, for example, on the first issue, which is the challenge to competition enforcement, we held 17 roundtables between 2018 and 2020 on issues that went from blockchain and competition policy, implication of e-commerce for competition policy, to issues of vertical mergers and merger control in dynamic market in 2019, then competition economics of digital ecosystem in 2020, data portability, interoperability, and competition in 2021, etc., etc. On the second issue, the wider issue of the appropriate goals of competition law, we held 4 roundtables during that period, nearly one each year, on how competition could contribute to fairer society, whether competition was under fire, and whether it was time for a reset of competition policy. Finally, on the question of the relationship between competition and regulation, we held 3 roundtables, one in 2019 and 2 in 2021, on independent sector regulators and competition, what their relationship was, but also ex-ante regulation and competition in digital markets, competition enforcement, and regulatory alternatives. 2022 has, to a large extent, been a transition year. Now, without disappearing, the concern that competition authorities would remain powerless to control the very large tech platforms and with their enormous might, gave way to other concerns. And I think that it's interesting to try to think why this happened. And there are a number of possible explanations. One of them is, of course, that competition authorities acquired, through the roundtables that I have mentioned, a better grasp of the issues, the competition issues in the digital sector. I think that the publication that some of you might be familiar, because a lot of those roundtables were summarized and analyzed in a document which was published last year by the OECD and which is available on the OECD site. A lot of this wisdom helps competition authority envisage how to deal with some of the issues raised by those digital platforms. I would, on a personal note, say that I think that there are still two blind spots, even though we have certainly improved our understanding of those issues. One of them is I'm not sure that we have put enough emphasis on analyzing the relationship between restriction to competition within ecosystem in relationship to competition between ecosystems. And I think that there are a complex relationship that we should analyze in more detail. And the second one is, I think that the relationship between innovation and competition in the digital sector still requires some thinking. The second reason why the digital sector is a bit less of a fixation for competition authority is, of course, also the regulatory dimension, the fact that in the EU, the DSA and the DMA were adopted, that we now have a regulation in Europe which is both a complement and a substitute to competition law enforcement. It's a complement because the goal of the DMA is wider. It is to impose fairness in the relationship between platforms and the complementers. But it is related to competition because a lot of the prohibitions which are in the DMA against the gatekeeper are in fact practices which have been analyzed from the antitrust point of view in various cases earlier on. So whether the DMA is going to do the trick, whether there is going to be a world effect of the DMA, a little bit like the RGPD, will be, I mean, it's too early to say, but at least we have this instrument. We are looking this year and next year for the beginning of its implementation, and maybe there's something which is going to change the nature of the debate. Third, competition law enforcement has picked up against a very large tech platform. I cannot go into the list of all the countries which have been involved, but if I take 2023, Alphabet, for example, has cases in Germany, in Mexico, in the US, and the Competition Commission of India has also sanctioned Alphabet. Amazon is under investigation by the CMA as well as by the US SEC over its use of third-party data for private label business. Apple is under investigation in the EU. It's under investigation in the CMA. It was under investigation in the Netherlands. It is under investigation by CAGE in Brazil. The US FTC is challenging Meta, and many other jurisdictions are. So the feeling that competition authorities were powerless towards those major platforms has changed because there's been much more assertion by competition authorities trying to deal with the issue. Fourth, I think it is also true that some signs of fragilities of the digital sectors have emerged. We know that together Amazon, Meta, Alphabet, and Microsoft, for example, will collectively incur more than 10 billion in charges related to mass redundancies and scaling down both their personnel and their offices to save costs because they are under pressure. We know that Google is facing stiff competition in artificial intelligence, and that might might lose this competition. We know that Facebook has lost a lot of its capital value, at some point nearly half of its capital value, because its results were not up to the expectation. We know that Apple is posting expected profit, I mean, it's posting profits which are below the expectations. And the sales of Apple have fallen in many parts of the world. And together with this, we know that there is a fundamental fragility of Apple due to its dependence on production in China. And if I go to Amazon, I mean, the turnover of Amazon has increased by 9% in the fourth quarter of 2022. But the same figure a year ago was 22%. So there's also a sense that things have become more difficult, more competitive, probably, in the digital sector. Fifth, and most importantly, I think that a number of new considerations have come to the fore and been important for competition authority. First, the disruption of the global value chains brought about by the COVID pandemic have shifted the economic debate from promoting economic efficiency to safeguarding the resilience of national economies. So we have a new goal, which is important socially and politically. Second, the COVID pandemic has also shown that markets work slowly and that there may be a need for state intervention to speed up or to correct the allocation of resources, and this has led to a revival of interest for industrial policy and government intervention in market mechanism. Third, the slowing down of globalization, or maybe the deglobalization, which started, by the way, around 2008, around the time of the financial and economic crisis. And the emergence of a multipolar world means that there is more scope for competition between nations or between blocs. Now, there's a very big difference between competition between blocs or nations and competition between firms, because the way nations compete is by erecting barriers to trade, to try to protect themselves against so they work against the competition between firms. So we've seen the rise of restrictive trade, industrial or investment policies, and there is a risk that this may reduce competition between firms on international markets. For the Ukrainian war, of course, has led to additional disruption in supply chains, which have fueled inflationary tendencies in a number of countries and on a number of politically very sensitive markets. And this has raised the question of whether competition could or should have any role in stopping this inflation, something that we will talk about today. Finally, concern about the climate change has brought to the fore the idea that competitive markets may have negative externalities, and that competition law enforcement, because it has a fairly short time perspective, may not be entirely adequate to think about the negative externalities that those markets may impose on societies. So the result of this evolution has been a resurgence of industrial policy, regulation, restrictive trade policies, and environmental policy, state subsidies, etc. Competition policy and law enforcement have had to contend with those forces, which in fact called into question its legitimacy and its relevance, as well as its effectiveness. So what did we do in 2022? I said we transitioned from concern with the digital economy to some of those new concerns. So we pursued our analysis of competition in the digital sector with a little twist, I would say. We had a roundtable on market power in the digital sector, in which we explored the different concepts of market power that come out of number of regulatory initiatives. So whether you call them gatekeepers or bottleneck power, platform power, intermediation power, strategic market status, we explore what were the similarities and the difference in those concepts, and whether the differences led to a lack of coherence of regulations across the world. But there are three other focuses of the work which occupied us in 2022. First, our discussion shifted to the interface between competition and regulation and other policies. So we held roundtables on competition in energy market, the relationship between FDI screening and merger control reviews, subsidies, competition and trade, interaction between competition authorities and sector regulators. So a set of 4 roundtables, which were the common point of all those roundtables is the relationship with regulators and other policies. One important issue that came out of those discussions was the issue of subsidies. I mean, clearly subsidies are on the rise in many countries, and they are not about to disappear very soon. And it's interesting from that point of view to contrast 2 roundtables that we had. The roundtable on the relationship between FDI screening and merger control. That showed that from a trade and industrial policy perspective, public subsidies are considered to be a major source of disruption in the era of international competition. At the same time, we held another roundtable on subsidies, competition, and trade. And there we realized that competition authorities very rarely deal with the issue of subsidies. And when they analyze competitive situation, they don't necessarily include the fact that some firms being subsidized, this leads to a different type of competition or restriction of competition compared to what would happen if those subsidies did not exist. So one of the lessons is maybe that competition authorities should pay more attention to the issue of subsidies in their analysis of competitive forces in order to better reflect some of the issues which are raised by those subsidies, at least at the international level. The second and the third focus of our discussion here were to try to answer the questions about the relevance and the effectiveness of our instrument. With respect to the relevance of competition law, we held 3 or 4 roundtables, one of the goals of competition policy, one on competition and inflation, one on integrating consumer behavior in competition enforcement, one on purchasing power and buyer's cartel, trying to explore various ways in which competition law enforcement could become more relevant to some of the issues which are raised outside of the competition world. I would like to make a very quick comment on competition and inflation. We are going to have this discussion later on today, but as the Secretary General remarked, I thought it was a very interesting roundtable because it was quite different in spirit from previous debates that had taken place on the issue of competition and inflation. There was a long tradition in the competition community to say, oh, inflation has nothing to do with us. Inflation is the increase in price. We don't deal with this. We deal with the level of price, which are either competitive or not so competitive. But inflation is a monetary phenomenon. There's nothing to see. Well, in the roundtable that we held this year, the mood was quite different, possibly because the inflation that we are facing is not a purely monetary phenomenon. The origin of it is, to a large extent, the disruption of supply and demand and disequilibrium between the two, which leads to a real increase in the price due to the scarcity. And the concern which has been expressed by a lot of competition authority is to say those movements might hide the fact that some firms which have market power use the inflationary context to raise their price even though they are not directly affected by cost, but just because they have the power to do it and it is the mood of the time. So competition authorities should be alert to this and should try to find out cases where increases in price really have nothing to do with disruptions of market, but have to do with the exercise of market power hidden under the general inflationary trend. So a very different perspective than discussion that we had before. Now, with respect to the effectiveness of our instrument, that's where we focused mostly. How can we show that our instruments are effective? How can we increase the effectiveness of those? So we held a roundtable on interim measures in antitrust investigation, and there is going to be a debate this afternoon about this, as one of the ways in which to increase, to go faster, to be able to intervene, to prevent some damage from happening. Data screening tools for competition investigation, disentangling consummated mergers, what were the experiences and the challenges of the competition authorities represented, remedies and commitments in abuse cases, and new type of remedies such as director disqualification and bidder exclusion in competition enforcement. So 2 quick comments on this effectiveness aspect. On consummated mergers and the ability to undo those mergers because it turns out that they are anti-competitive even if either they were not examined originally or it was not realized originally that they would lead to anti-competitive effect. I think that there was a certain caution. First of all, there are difficulties. What kind of data can you use? Is post-merger data? How do you gather? I mean, do you have the power to gather this data and how this data can be used? What are some of the instruments that can be used to reconstitute the eggs from the omelet, and we know that this is difficult. So the availability and the proportionality of effective remedies was very much discussed, and I think there was a little bit of a word of caution about going back to mergers which have been consummated in the past. My last comment will be on the data screening tools. One of the observations that we have is that cartel activity has not disappeared, but some of the tools that we have to uncover cartels may not be as effective as they used to be. And in particular, this is the issue of leniency program, which in some jurisdiction doesn't provide as much information as it used to because firms are reticent to use this tool. Hence, there is a need for competition authorities to substitute or to complement this tool with other tools to try to detect violations and cartel violations. And this is where, for example, techniques like data screening might come in handy. So we looked at those new tools and how they could be adapted in a variety of circumstances. I have given you some of the ideas of the work and the sense of the direction of work that we have done. Of course, I hope that you can, I know that you can go online and find documents on all those themes, and I very much encourage you to do this. And as the Secretary General said, this afternoon you're going to get a sense of different, this morning and this afternoon, we're going to start with a discussion on the global trends of enforcement, and then we are going to go directly to effectiveness and relevance of competition this afternoon on both relevance to inflation and effectiveness with interim measures. So that will give you a sense of what we've been doing. So thank you very much for being here. I just want to add a personal note. Because one of the least pleasant duties of the chair of the Competition Committee is to say goodbye to some members who are about to disappear from the scene because professionally they move to other activities. And I want, from this point of view, to thank very much and Margarida Matos Rosa, who is the head of the Portuguese Competition Authority, and Margarida is, for the last time at OECD, as the chair of the Portuguese Authority, which of course doesn't mean she's not going to come in as an expert in the future in this, at the OECD. I want to mention the fact that she's been an extraordinarily active member of our community. First of all, because she had an institutional function, which was to be the link between the OECD and the ICN, and to ensure that there would be no redundancies between the two institutions. They would mutually support each other. Other than that, she has been an extraordinarily effective enforcer in Portugal, where she has a wonderful record, both on the side of antitrust enforcement, where the Portuguese Competition Authority has done remarkable work, but also on the side of advocacy. Just to give one idea, I know that in 2021, the Portuguese Competition Authority issued over 35 opinions, studies, and recommendations on draft and existing legislation and regulation across many sectors. That's just to give an impression of the importance that the Portuguese Competition Authority had. So thank you very much, Margarida, for all you did for us. We benefited immensely from your presence, and we're very thankful for all the time and the effort that you devoted to this institution. My second I also want to mention the fact that there is another head of authority who is going to leave our community, Šarūnas Keserovskas, who is the chair of the Lithuanian Competition Council. This is also the last time that he is with us as the chair of the Lithuanian Competition Council, where he has served 2 6-year terms and has built up this institution, which originally was more concerned with price regulation, into a real and very effective competition authority. Before that, he had been with the OFT as a senior legal advisor since 2009, and before that, he was a lawyer interested in competition issue. He has had also domestically a very impressive achievement in building a modern institution, ensuring the transition from a very different system and making sure that this institution was up to speed with the best practices that exist. But also I have a particular word for Šarūnas, because he participated extremely actively in the Competition Committee and in a particular way. He was never shy about taking controversial positions and explaining why it was that he was taking those positions. And some of them had to do with the fact that he was operating in a different environment than many other competition authorities. Some others had to do with the fact that he had deeply thought about some issues, and he could explain why he wanted to differ from the rest of the community. So this has been extremely useful for us, because it has helped us reconsider some of our convictions, and this is really one of the things that the OECD discussions can bring, which is the diversity and the confrontation of point of view. And finally, I want to welcome, because this is the positive side of being the chair, Gina Klaas-Gottlieb, who is the head of the ACCC in Australia. She was a highly respected, and from what everybody has told me, formidable competition lawyer before she came, and formidable in the sense that the ACCC was very wary of her before she became the chair. And she has also functioned on the Australian Payment System Board, which is the regulator of access to payment system and financial regulatory assessment authority. So the ACCC already has a considerable scope of activity, because it is both a competition agency and a regulator, and has consumer protection duties. But on top of that, at a personal level, she also has, in the financial sector, personal involvement. So we're very hopeful to work very closely with you, and I want to very warmly welcome you to the community. So thank you very much.